Good morning, everyone. My name is Alan Sousie. I'm Director of Nursing at TLC Home Care, and I am interested today in offering you some information about the use of social media as professional caregivers. Welcome to TLC Academy. I'm taking my information today from a nurse's guide to the use of social media that was actually published by the National Council of State Boards of Nursing in 2011. Social media is an exciting and a valuable tool when you use it wisely. The very nature of this medium, however, can pose a risk as it offers instantaneous posting opportunities that allow little time for reflective thought before you post, and it carries the added burden that what is posted on the internet is discoverable by a court of law, even when it is long deleted. Caregivers and other health professionals are welcome to use social media in their personal lives. Caregivers can positively use electronic media to share workplace experiences also, particularly those events that are challenging or emotionally charged. But it is imperative not to mention clients by name or to provide any information or details that could possibly identify them in order to protect the right to their privacy. I want to talk a little bit now about social media in the workplace. Social media can benefit healthcare in a variety of ways, including fostering professional connections, promoting timely communication, and that happens both with your clients and also with family members. It can be used for educating and informing consumers and other healthcare professionals as well. Social media also provides caregivers with a way to express feelings and reflect or seek support from their friends or their colleagues or their peers or basically anyone on the internet. Without a sense of caution, however, these understandable needs and potential benefits could result in the caregiver disclosing too much information and actually violating privacy and confidentiality. Healthcare organizations that utilize electronic and social media, like TLC, typically have policies governing employee use of such media in the workplace. Organizations also maintain careful control of websites and maintain them by or associated with any of our organizational outlets. And we limit what we post and what may be posted to a site and by whom it can be posted. For example, when we set up any kind of a communication blog or system, here at TLC, it is controlled by someone within the core team. Employer policies, however, typically don't address caregiver use of social media to discuss workplace issues outside of work, on home computers, and personally owned phones, or other handheld devices such as an iPad. It is in this context that the caregiver may face potentially serious consequences for inappropriate use of the social media. And I want to give you an example of what type of situation might be an inappropriate use of social media. Jamie has been working in a hospice care for the last 6 years, and one of her clients, Maria, maintained a hospital-sponsored communication page to keep friends and family updated on her battle with cancer. One day, Maria posted about her depression. As her caregiver, Jamie wanted to provide support to Maria, so she posted, "I know the last week has been difficult, Maria. Hopefully the new happy pill will help you, along with the increased dose of morphine. I will see you on Wednesday." The site automatically listed the user's name with each comment. The next day, Jamie was shopping at the local grocery store when a friend stopped her to ask about Maria's condition. "I saw your post yesterday," her friend said. "I didn't know you were taking care of Maria. I hope that new medication helps with her pain." This is actually a great example of a violation of confidentiality on social media. While Jamie had Maria's best interest at heart by trying to offer her words of encouragement, she inadvertently disclosed information about a patient on the social media site. Everyone who read that post now knew about Maria's antidepressant medication and the increase of her morphine. This violated Maria's right to privacy and confidentiality. Instances of inappropriate use of electronic media by caregivers such as this one have been reported by many boards of nursing, and in some cases demonstrated in nursing literature and other public media. To understand the limits of appropriate use of social media, it is important to have an understanding of confidentiality and privacy in the healthcare context. Confidentiality and privacy are related, but distinct concepts. Any client information learned by the caregiver during the course of care must be safeguarded by that caregiver. Such information may only be disclosed to other members of a healthcare team and for the specific purpose of providing the best care for the client. Confidential information should be shared only with the client's informed consent, and when legally required, or where failure to disclose the information could result in significant harm to the client or someone else. Beyond these very limited exceptions, a caregiver is obligated to safeguard all confidential information. I want to give you another example. As a licensed practical nurse for more than 20 years, Bob knew the importance of safeguarding a client's privacy and confidentiality. One day, Bob used his personal cell phone to take photos of Claire, a resident in the group home where he worked. Bob received permission from Claire's brother to take the photos, and since she was not able to give that consent due to her mental and physical conditions, Bob assumed that the authority coming from her brother was acceptable. That evening, Bob ran into William, a former employee of the group home. While catching up, he showed William the photos of Claire and discussed her condition with him. The administrator of the home later learned of Bob's actions and terminated his employment for breach of confidentiality. You may be asking, well, why was he terminated for breach of confidentiality when he had permission of the brother of the client? Obviously, Bob thought it was okay for him to take Claire's photo because he did have the consent of a family member. He also thought it was acceptable for him to discuss Claire's condition because William previously worked with Claire. So why was it wrong? Well, because first, merely asking Claire's brother for permission is not obtaining a valid consent. And second, confidential information should not be disclosed to persons no longer involved in care of the client. Even though Bob made an honest mistake, confidentiality rules must be strictly enforced in order to protect a client's rights to privacy. Privacy relates to the client's expectation and right to be treated with dignity and respect. Effective relationships are built on trust. Clients need to be confident that their most personal information and their basic dignity will be protected by a caregiver. Clients will be hesitant to disclose personal information if they fear it will be disseminated beyond those who have a legitimate need to know. Any breach of this trust, even inadvertently, damages the caregiver-client relationship and the general trustworthiness of our profession of healthcare providers. The federal law, Health Insurance Portability and Accountability Act, commonly known as Hipaa, it defines individually identifiable information as any information that relates to the past, present, or future physical or mental health of an individual, or information which provides enough facts that leads someone to believe the information could be used to identify the individual in the facts. Breaches of client confidentiality or privacy can be intentional or inadvertent, and they occur in a variety of ways. Caregivers may breach confidentiality or privacy with information that they post via social media. Some examples may include comments in which clients are described with enough sufficient detail to be identified, referring to clients in a degrading or demeaning manner, or posting videos or photos of your clients. Potential consequences for inappropriate use of social and electronic media vary. The consequences depend in part on the particular nature of the caregiver's conduct. Depending on the laws of a particular jurisdiction, a report may be given to a local board of nursing, which may then investigate. The Board of Nursing is the typical recipient of violation reports for nurses and LNAs. PCAs are usually investigated and reprimanded by an employer. Boards of nursing and employers may act on the grounds of the following: unprofessional conduct has been conducted, unethical conduct has occurred, moral turpitude, which is defined as conduct that is considered contrary to community standards of justice, honesty, or good morals. Mismanagement of patient records may be another criteria. Revealing a privileged communication and breach of confidentiality. These are all typical grounds for action to be taken by an employer or the Board of Nursing. If the allegations are found to be true, the licensed caregiver may face disciplinary action by the Board of Nursing, including a reprimand or a sanction, assessment of a monetary fine, or temporary or even permanent loss of licensure. These things could also apply to a PCA on the part of an employer. There could be some form of sanction, an assessment of a suspension of work with money associated, or even removal from your employment. The improper use of social media by caregivers may actually violate state and federal laws. Such violations may result in both civil and criminal penalties. They could include fines and possible jail time, depending on the severity of the nature of the information. A caregiver may face personal liability and even be individually sued for defamation, invasion of privacy, or harassment. And particularly flagrant misconduct on social media websites may also raise liability under state or federal regulations that are focused on preventing client abuse or exploitation. If the caregiver's conduct violates the policies of the employer, the caregiver may face employment consequences, and they include termination. Additionally, the actions of the caregiver may damage the reputation of the employer or subject the organization to a lawsuit or regulatory consequences. There's another concern that arises from social media misuse, which is its effect on team-based care. Online comments by a caregiver regarding coworkers, even if posted from home during non-work hours, may constitute lateral violence. That's what's known as disruptive behavior of intimidation and bullying, and that may be perpetuated in person or via the internet. This is sometimes referred to as cyberbullying, another way to look at it. Such activity is a cause for concern to current and future employers and regulators because it negatively affects team-based care, and it may cause patient safety ramifications. The line between speech protected by labor laws, the First Amendment, and the ability of an employer to impose expectations on employees outside of work remain under constant scrutiny and debate. Notwithstanding, it should be obvious to all caregivers that negative comments are usually detrimental, and they may result in sanctions against you. It is best to avoid such consequences in the first place. Before we close, I want to share some common myths and misunderstandings about social media. While instances of intentional or malicious use of social media have occurred, in most cases, inappropriate disclosure is unintentional. A number of factors contribute to caregivers inadvertently violating privacy and confidentiality. They include these: a mistaken belief that the communication or post is private and accessible only to the intended recipient. Caregivers may fail to recognize that content once posted or sent can be disseminated to other people. A mistaken belief that content deleted from a site is no longer accessible. The moment something is posted, it lives on a server that can always be discoverable in a court of law. A mistaken belief that it is harmless if private information about clients is disclosed when the communication is accessed only by an intended recipient. This is still a breach of confidentiality. Another mistaken belief that it is acceptable to discuss or refer to clients if they are not identified by name, but referred to by a nickname, a room number, a diagnosis, or a condition. This too is a breach of confidentiality and demonstrates disrespect for the client's privacy. And last, a persistent confusion between a client's right to disclose personal information about him or herself or a healthcare organization's right to disclose otherwise protected information with client consent, and the need for caregivers to refrain from disclosing patient information without a care-related need for disclosure. The ease of posting and the commonplace nature of sharing information via social media may appear to blur the line between one's personal and professional lives. The quick, easy, and efficient technology enabling use of social media reduces not only the time it takes to post, but also the time to consider whether the post is appropriate and what ramifications may come from posting inappropriate content. So how do we avoid disclosing confidential patient information? With awareness and caution, as a caregiver, you can avoid inadvertently disclosing confidential and private information about your clients by following the guidelines which are intended to minimize the risk of using social media. Here's some examples of guidelines. First, caregivers must recognize that they have an ethical and legal obligation to maintain patient privacy and confidentiality at all times. Caregivers are strictly prohibited from transmitting by way of an electronic media any client-related image. In addition, caregivers are restricted from transmitting any information that may be reasonably anticipated to violate client rights to confidentiality or privacy, or otherwise degrade or embarrass the client. Caregivers must not share, post, or otherwise disseminate any information or images about a client or information gained in the care relationship with anyone, unless there is a care-related need to disclose the information or some other legal obligation to do so, such as being ordered by a court of law. Caregivers must not identify clients by name or post or publish information that may lead to the identification of a client. Limiting access to postings through privacy settings is not sufficient to ensure privacy. Another example, caregivers must not refer to clients in a disparaging manner, even if the client is not identified. Caregivers must not take photos or videos of clients on personal devices, including cell phones. Caregivers should follow employer policies for taking photographs or videos of clients for treatment or other legitimate purposes using employer-provided devices, not their own personal devices. Caregivers must maintain professional boundaries in the use of electronic media. Like in-person relationships, the caregiver has an obligation to establish, communicate, and enforce professional boundaries with clients in the online environment. Use caution when having online social contact with clients or former clients. Online contact with clients or former clients blurs the distinction between a professional and a personal relationship. The fact that a client may initiate contact with a caregiver does not permit the caregiver to engage in a personal relationship with the client. Caregivers must consult an employer's policies or an appropriate leader within the organization for guidance about social media relationships with clients and associated work-related postings. Caregivers must promptly report any identified breach of confidentiality or privacy. I repeat, caregivers must promptly report any identified breach of confidentiality or privacy. Caregivers must be aware of and comply with employer policies regarding the use of employer-owned computers, cameras, and other electronic devices, and use of personal devices while at work. Caregivers must not make disparaging remarks about employers or coworkers. Do not make threatening, harassing, profane, obscene, sexually explicit, racially derogatory, homophobic, or other offensive comments online. And finally, Caregivers must not post content or otherwise speak on behalf of the employer unless they are authorized to do so. And they must follow all applicable policies of the employer. So what is the conclusion of all of this information? Well, social and electronic media do have tremendous potential for strengthening personal relationships and providing valuable information to healthcare consumers, as well as affording we healthcare providers a valuable opportunity to interface with colleagues from around the world or from within the city we live in. Caregivers need to be aware of the potential consequences of disclosing client-related information via social media. And we must remain mindful of employer policies, relevant state and federal laws, and the professional standards regarding client privacy and confidentiality, and how it is applied to our social and electronic media use. By being careful and conscientious, we caregivers may enjoy the personal and professional benefits of social and electronic media without having any violations of patient privacy and confidentiality. So with that said, I leave you today asking you to rethink how you have been using social media, whether it be in your professional life or your personal life. And remember, there may be some significant consequences, even inadvertent consequences, if you misuse social media and violate another person's privacy or confidentiality. Thank you for your attention to today's program.